is going to be our approach. So these two are the important topics. So first I will take about 20-25 minutes on the labor code and the remaining 20-25 minutes on pay commission. Labor codes, all of us know, being working in the trade union. 100 years, more than 100 years, the Indian working class fought for whatever rights we are having today. In fact, this year, 2026, is the centenary of the Trade Union Act in 1926. The entire working class and the trade unions of the country has to celebrate 100 years of Indian Trade Union Act. But unfortunately, today that act is not here. That no act is finished. That act is abolished. And you are in the outskirts of Chennai. Chennai has got an history. And Chennai workers are the main reason for the passage of Indian Trade Union Act 1926 in the British Parliament. Even though prior to 1926 in Bombay, in Nagpur, in different parts of the country, workers have organized unions, associations and all. But the impact which has been created was in Chennai. In Chennai there is a place called Perambur, where you know the integral coal factory is there. So near that Perambur railway station there was a big textile mill in those days. It was called as Buckingham and Carnatic mills, BNC mills. And the brand of that cloth which is manufactured in that mill is called pinni. And that cloth in those days was not easily available in the market. You have to take a quota. My father was having the quota of the pinni mill. Every month they used to give this many meter of trouser piece, this many meter of shirt piece, like that. So in that mill, in those days, 1917, 18, 1919, during that period, 25,000 workers were working. Women, children, men, and no working conditions. 16 hours, 17 hours, they have to work. No toilet facilities, no canteen facilities, no potable drinking water, no proper ventilation, no safety precautions. And workers were all dying in a very younger age because of tuberculosis and not because of the cotton dust being consumed by these workers. So the great freedom fighters of those days, Comrade Singaravelu, Tirivi Kalyana Sundaram, B.P. Vadia, Shakare Chettiar, all these big leaders, after seeing the fate of the workers of this BNC mill, they only started organizing them, bringing awareness in them. And subsequently, the Madras Labour Union, the first organized trade union of our country, FLU, was formed. And British took it as a criminal act. Criminal cases were charged against them, like Meerut conspiracy, Kanpur conspiracy. This was Madras conspiracy. These people organized the workers against the British government. Trade union was formed. Workers were asked to struggle for their rights. That was the charges. And the British judge in the Madras High Court, one of the oldest High Court in our country, has accepted it as a criminal offence. Then only the Labour Party MPs of the British Parliament, they raised this issue in the Britain Parliament. Because if you go through the history, the Britain Trade Union Act was passed in the year 1871 by the British Parliament. So the workers of the Britain are entitled for forming a union as their right from 1871 onwards. So the Labour Party MPs raised in the British Parliament asking them Your government is only in India. The king is only ruling the India. It is the British government which is running the government there. How can you have a discrimination? Your government in Britain has given trade union right to the British workers. And why you will not give the same right to the Indian workers? So that debate went for so many years, and as an outcome of that only in 1926 the British Parliament passed the Indian Trade Union Act 1926, thereby giving a legal status for the union. You can register a trade union legally and with a lot of legal protections for the union, its office bearers and all those things. Now after 100 years, in 2026 now we are all standing here, that act is abolished. That act is no more there. Similarly, in 1947, Baba Saheb Ambedkar was the labor minister in that interim government. Considering the conditions of the Indian workers, the ID Act 1947, Industrial Dispute Act 1947 was passed, giving the strike, right to protest and strike as one of the right to the workers. And so many other protective classes. I am not going into the detail because of shortage of time. You can go to the labor courts, that is from there. You can have a bus committee elected by the workers to represent their welfare related issues. And any change in the service condition, a notice has to be given to the workers. Without giving a notice, no service condition can be changed. All those protections were there in the ID Act 1947. You can raise an industrial dispute, and that ID Act only defined what is an industry. And on that, subsequently, the constitutional bench of Justice V.R. Krishna here, in the case of Bangalore Waterworks and Rajappa versus Rajappa, gave a historical judgment, giving the clear definition of what is an industry. All these are of ID Act 1947. Today, where is that ID Act? It is also abolished. In an industry where more than 100 workers are working, the management and the unions have to jointly, for their bilateral discussions and negotiations, to frame the various codes of conduct and all those things. The Standing Orders Act was there. Now that is also finished. So these three has now become IR Code 2020, Industrial Relation Code. Then all of us, including the defense employees, they are all governed under Factories Act 1948 because we are working in a factory which is registered under the Factories Act 1948. So many protections are there. The Factories Act only specifies 8 hours working. And if you work beyond 48 hours in a week, overtime at double the rate. And if so many workers are working, so many toilets are required to be provided. Potable drinking water has to be provided. Proper ventilation has to be provided. There should be a canteen, statutory industrial canteen, which has to be managed in a no loss, no profit basis. And the management is responsible for giving various facilities for the canteen. These are all part of the Factories Act. And whether atomic energy workers or the defense workers, we are all working in a highly risk and hazardous nature of job. We are dealing with nuclear energy, atomic energy, and we are dealing with all types of ammunition, explosives, chemicals, acids, whatnot. And for that, personal protective equipment, PPE has to be given. Safety precautions have to be maintained. Central Safety Committee should be there, in which workers' representatives will be there, Section Safety Committee will be there. All these are in the Factories Act. Where is that Factories Act? That is also finished. Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, 29 labor laws, comrades, have been abolished. And all those, according to the government, is subsumed in the 4 labor code. And government machinery propagates through media, through the labor commissioners, through the managements, that these acts are beneficial for the workers. These acts are made for the betterment of the workers. Trade unions are unnecessarily opposing. Press people also used to ask me, wherever I go, government is telling this is good, that is good. Only trade unions, unwantedly, they are opposing. And that is one of the reasons why the Chief Justice of India, in a case connected with the domestic workers, somebody was gone to court. Domestic workers who are doing what we call housemaid, servant maid, in different names it is called. They are not at present governed under any statutory labor laws. So their union or association went to the Supreme Court telling that these workers should be given the status of a worker. While that case was going on, the Chief Justice of India, after all a common man in India, even though we are in a democracy, we have got a parliament, we have got an elected government, ultimately the little bit of a ray of hope is only the judiciary. And that to the apex judiciary, which is called as the Supreme Court. And the Chief Justice of that Supreme Court has made a comments without any data before him, without any evidence. Trade unions are responsible for closure of industry in this country. This is coming from the mouth of a Chief Justice. And judiciary generally goes by evidence. The facts which are brought before its notice. That is how judgments come, whether it is criminal case, civil case, whatever it may be. But this gentleman is telling industries are closed in this country only because of the Janda unions. Indirectly meaning the red flag unions. Because they only hold the flag in their hands when they do agitation or when they do any rally or in their own meetings. But what is the fact? Last year in the Indian Parliament, the Labour Minister has given reply, Industry Minister has given reply. In the past 5 years, 222,000 factories are closed. Past 5 years. So the next question asked by the MP is, what's the reason? And the reply given in the Parliament, in the floor of the House, by the Minister is, because of so many reasons. The management doesn't want to run the factory, or the management want to merge the factory, or they want to close down the factory, or there are problems like raw materials, or problems like not diversifying the products. Like that, so many reasons. But the minister has not told. Well, another reason is trade union action, indifferent attitude of the trade unions, non-cooperation of the trade unions. That has to be told by the minister if it is so. Never told. Another reply. How many NTC, National Textile Corporation mills, which are public sector, are closed in this country? The reply of the Textile Minister is 23 NTC mills are closed. Why it is closed? It is closed because of COVID-19. Then the MP asked, Then why it is not reopened? No, after COVID-19 it was not reopened. That was the answer. How trade union becomes responsible for this. So this is the mindset, this is the attitude. And I tell these people who are asking me, everybody, every industrial body in this country, every employer body in this country is welcoming this. Confederation of Indian Industry has welcomed, ASSOCHAM has welcomed, FICCI has welcomed, and so many employers organization has welcomed. It's a wonderful thing Modi government has done. If something is good for the worker in this code, will these fellows welcome this? Let us not do research. People like me, even now, I have studied not even 15% of the labor code, whatever they have implemented. What is going to be implemented? Because you have to compare with the previous act. 29 acts, their provisions have to be compared with these 4 labor codes. Then only you will understand what is good or what is bad in that. That study is still going on. So without going into all those things, the matter is very simple. If all these fellows are welcoming the labor code, that means it is in their favor. If it is not in their favor, why they will welcome this? That itself is a proof that these 4 labor codes are not in the interest of the workers of our country.